I will start this presentation with the introduction. 1977 Act stated that where there was a conflict between common law rule and equitable rule, the equitable rule were to take precedence. The maxim of equity are general rules that Chancery Court and modern court used to decide whether or not to grant equitable remedies at its own discretion. Maxim is known as a set of general principles that are set to govern the way the equity operates, illustrating the quality of equity. It was characterized by a greater adaptability and responsiveness to the need of individual, as well as a greater propensity to take into account the parties' behavior and merit. It was established by English Court of Chancery in collaboration with other courts which have equity jurisdiction. Equity looks to the substance rather than the form. Bring means that equity looks to the intention of the parties and not the word. The case of Parkin and Thorold, Lord Rumley acknowledged the principle when he stated equity will distinguish which is a matter of substance and which is a matter of form. Another example is the right or equity of the person who had mortgage on a property to pay it off. Even if the mortgagor has been late with the payment or breached the term of mortgage contract, equity will still side with the mortgagor's right to redeem the mortgage. Last but not least, the objective of this study is to give clear understanding on how to determine to what extent the maxim of equity looks to the substance rather than the form should be applied when dealing with formalities and procedure.
Prior to advent of equity, the common law placed great emphasis on the adoption of proper forms and procedures in connection to any act, and failing to follow such forms rendered all actions, whether they were suits or agreements, invalid. Due to its rigidity and inflexibility, the common law was unable to respond favorably to the demand of time. It believed that the form of a transaction was more significant than its substance when it comes to the accusation and property transfers. Therefore, rather than strictly adhering to forms, equity per se was established with the purpose of achieving justice. The Constitution supports this approach to technicalities and requires the courts to deliver justice without undue consideration of technicalities. Equity focuses on the parties' intentions rather than their words, and the facts instead of just appearance. Focusing on form defeats its aim. However, even though it goes against original aim, insisting on form is a significant element in any transaction. Allowing someone to focus on form reduces the importance of intention and is unjust. The intent is preferred if the transaction is still incomplete. Its application is as in such cases below. Firstly, specific performance. When one party agrees to buy another's immovable property, the agreement of sale contains a condition specifying that on a specific date the deed of sale must be executed to fulfill the terms of the contract. The question of whether the party who allowed those days to pass can initiate a claim for specific performance arises if the sale deed is not completed on the planned date, resulting in a breach of contract. The answer is based on what the parties intended when they signed the agreement. The primary aim was to buy the property, and the deadline set for the sale deed's completion served mainly to ensure that the agreement of the sale was performed. Secondly, penalties. It is applied in situations where legal duty exists but the reasonable time extension would make it possible to complete the transaction within the allocated time frame. Certain agreements include conditions stating that in the event of a breach, the party liable must pay a specific amount to the opposing party. It is the nature of a penalty when the amount payable is a punishment for breaching of the contract. Besides, the allocation of sum as the amount payable in the event of a default serves only as an incentive or security for the performance. A sum allocated as a penalty is meant to intimidate the other party into performing the contract, whereas sum allocated as damages is meant to ensure that the other party actually fulfills the contract. The Court of Equity does not allow penalties, but does accept damages that were really incurred due to the breach. Next, forfeiture, a condition that gives the landlord the right to re-enter and terminate the lease in the event of unpaid rent. Such a provision is just included in lease as an insurance of the timely payment of rent. The intention is for the lessee to pay the rent on time after being coerced to do so by the prospect of losing the lease, not that he would be ejected. Therefore, if the lessor could get compensation, the Court of Equity would not decree forfeiture for non-payment of rent. This became possible when the lessee paid the lessor in the court full amount owed to him for rent, interest on the amount, and all litigation costs. And lastly, redemption. The right of redemption belongs to the mortgagor. Redemption is the act of paying off a mortgage debt or other charge on property so that the legal estate and equitable interests are combined. It is also referred to as buying back the property. The mortgagor files a redemption action to reinduce the mortgagee to reconvey the property upon payment of the loan and interest. Additionally, it refers to a mortgagee's equitable right to redeem the property after the legal right to do so has been lost due to a failure to make the required mortgage repayments on time. This also refers to a mortgagee's equitable estate or interest in the mortgaged land over which an equitable right of redemption exists.
Moving on to the next case law, which is Majlis Peguam Malaysia and Raja Gopal Adat Lelaki Value and another. The parties of this case are the appellants, where they are the one who takes action against the first respondent's misconduct. While for the respondent, we have two respondents, which are the first respondents, where he is an advocate and solicitor, and the second respondent, where he is the complainer of the first respondent's misconduct. In this case, the attestation of two signatures was made in respect of the property transfer form, which is Form 14A by the first respondent. However, one of the signatures that had been attested was done when the owner of the property, which is the second respondent's mother, had already passed away. While for the other signature, which is by the vendor, Madam Ponama also claimed that she had never signed the document. As a result from the first respondent's misconduct, the property was deprived from the complainant to the purchaser, Su Chi Ming. The first investigation were done by the Investigating Tribunal IT and carried on by the Disciplinary Committee, DC, to look into this matter further. It was found that the first respondent was guilty and will be suspended from practicing as an advocate and solicitor of the High Court of Malaya for 12 months. The first respondent then proceed to appeal to the courts because he is dissatisfied with the decision of the investigation and the punishment. In the court decision, the federal court had applied the equity look at the substance rather than the form for the first issue. It was found that the first respondent does get informed sufficiently regarding the complaint because he had fully cooperated in the proceeding, and according to his letter of explanation of his misconduct, there was also no procedural injustice and breach of natural justice were found by the court due to insignificance for Miss Abigail MS Lee from Measures KL Lim and Lee to testify, because it doesn't change the fact that the first respondent had attested the vendor's signature while the vendor is absent. Besides, according to the LPA, no formal charge needed to be framed against the first respondent. The first respondent will only be suspended for 6 months instead of 12 months from practicing as an advocate and solicitor. The last case law that we will elaborate is a Singapore case law in order to compare the applicability of equity look to the substance rather than the form. In the case of Denka Advantage Private Limited and another and Seraya Energy Private Limited and another and other appeals, the parties of this case is the appellant Seraya Energy Private Limited, where the company is an electricity retailer that fully owned subsidiary of YTL Power Seraya Private Limited, while for the respondent, Denka Advantage Private Limited and Denka Singapore Private Limited, where they are Seraya's customer. For the further case, under the Steam Supply Agreement SSA between the SPL and YTL, YTL will provide the SPL minimum amount of steam monthly. In June 2012, the SPL then asked to lessen the quantity of the steam that was required to purchase according to the SSA. In August 2012, YTL then made a concession to the SSA's original term to the SPL, which is the concession offer, in accordance with the terms and conditions in the concession terms. The parties now entered into Ancillary Supplement Agreement ASA to finalize the concession terms. However, the ASA was not executed between them. After that, the parties started carrying out the ASSA as modified by the concession term, where Denka and Seraya will be in long-term electricity retail agreement (ERAs). Denka and Seraya entered into a total of 3 ERAs, which are Era 99, Era 100, and Era 101. On July 2014, Denka then communicated that they wish to go back to original condition of SSA and put the ERAs to an end. The SPL wrote to YTL stating that the supply of steam and electricity shall cease under the concession offer, and the ERAs which viewed as evidence that ERAs was repudiated, and Seraya accepted the SPL's repudiation of Era 100. Era 99 and Era 101 were subsequently terminated by Seraya and other reasons. Seraya then claimed that Denka had breached all 3 ERAs. However, Denka denied liability for wrongful termination of the ERAs because Denka are not obliged to purchase minimum volume of electricity from Seraya each month. It was also argued that the letter wrote by the SPL did not amount to termination and the ERAs were not standalone contract. Besides, the SPL also argued that the parties did not execute the ASA in the end, and Denka was thus free to walk away from the ERAs. For the court decision, the court had applied that maximum of equity looks to the substance rather than the form, so that the contextual approach to the contractual interpretation is in accordance with the circumstances of the case. It was found that Denka had wrongly rescinded from all 3 ERAs, and Seraya had validly terminated the ERAs. For the claim of common law damages, the court had allowed Seraya's appeal on its claim under the liquidated damages clauses due to the loss of bargain. And lastly, the court had granted Seraya more than $30 million Singapore dollars, which is the amount of that owed according to the liquidated damages clauses in ERA.
In conclusion, equity maxims are not rules that must be followed in every circumstances. Rather, they are served as a general guide that show how equitable court would use its power. These equity maxims also lack of logical division, which means none of them completely cover the entire field of equity. Moreover, they are overlapped and have connection with each another. The notions that equity looks to substance, not to the form, can create a false opposition. Attention to the form of legal relation that a crucial step in considering the justification of particular substantive outcome. The basic claim in many cases is that the importance and the uniqueness of the equitable rules lies in the fact that such rules regulate in favor of specific claimant the enforcement of a right of the defendant. It means, although they have been tied to the common law norms, equitable rules frequently have distinct outcomes. Secondly, the nature of the rules may make some problems with their reasoning easier to tackle. Such regulation in particular might be considered as contributing to the mitigation of the impact of main regulation, thus reducing some of the danger that occur when the law acknowledges a power of establishment or transfer rights. To conclude, there are always many questions relating to the establishment of judicial rule, and to answer such questions with the context to establish judicial rules, whether such rule arose at common law or in equity, we must look at the form as well as the substance.